Hi everyone, once again welcome you to our page, Know the Law. My name is Joel Ivan and I'm taking you through land tenure systems in Uganda. So in order to understand the concept of tenure systems in Uganda, we first of all have to understand what land is. Therefore, the Blackstone Dictionary, 9th edition at page 955, defines land as an immovable three-dimensional area consisting of a portion of the earth's surface, the space above and below the surface, and everything growing or permanently affixed to it. So by this definition given by the Blackstone Dictionary, we get two important aspects under land. One of them is the aspect of fixtures, the quick quid plantato solo sedit, which is loosely interpreted as whatsoever is fixed on land becomes part of it and belongs to the landowner, right? I believe we looked at fixtures and exceptions to this rule, right? Then another aspect is meaning of land. Whosoever owns land owns all the surface above till heavens and all the way to hell. And I believe you also looked at the exceptions where we are told that regardless of the fact that you own land till the heavens, literally you cannot own land till the heavens, right? You own land until a reasonable height, right? Anyways, let's look at a tenure. A tenure is an interest of a land for a given period of time. Why is it a given period of time? It's because you cannot own land for ages and centuries. Because in due course of your life, your lifetime, you may decide to sell that land off, or at your death, yes, that land becomes somebody else's property. It ceases to be yours, right? Anyways, therefore, land tenure system is the relationship that individuals and groups hold with respect to land and land-based resources such as trees, minerals, pastures, and water. So that is land tenure. Okay, that's land, then tenure, then land tenure, right? So we are going to be guided by the Constitution of the Republic of Uganda as amended. We are also going to look at the Land Act 1998 as amended. Okay. Let's begin with Article 26, Clause 1 of the Constitution. It provides that all people have a right to own property either individually or in association with others. So my question is land property? Yes, land is property. And if land is property, the Constitution tells us that we have a right to own land either individually or in association with others, right? So Article 237, Clause 1 provides that all land belongs to the citizens of Uganda and shall hold it according to the tenure systems provided under the Constitution, right? So the Constitution is trying to tell us that yes, you have a right to own land, but you only own land under the given tenure systems we have in Uganda. So Article 237, Clause 3, read in conjunction with Section 2 of the Land Act, provide that subject to Article 237 of the Constitution, all land in Uganda shall rest in the citizens of Uganda and shall be owned in accordance with the following tenure systems. 1. Customary. 2. Freehold. 3. Milo, 4. Leasehold, right? So they're telling us that you only own land under the 4 tenure systems, one of them being customary. Secondly, we have freehold. Thirdly, we have Milo. Then lastly, we have leasehold, right? Anyways, let's look at customary tenure system. We're going to be guided by the following questions. 1. Assess the impact of written laws on customary land tenure systems in Uganda. Then 2. It's in quotation. Written laws did not provide for security of tenure to customary landholders. Close quotation. Discuss the foregoing statement in light of the pre-colonial, colonial, and post-colonial era. So we also have to understand what amounts to customary tenure system, right? So Section 3, Subsection 1 of the Land Act defines customary tenure as a form of tenure applicable to a specific area of land and a specific description of class of persons. So we should read this section in conjunction with the definition given by Justice Mubiru. In this case of Atunya, yes, Atunya, Valirano versus Okane Delfino, High Court Civil Appeal number 66 of 2012, citing with approval the case of Oyekam versus Andele. This is 1957. He defined customary tenure as a system of land tenure regulated by laws or customs which are limited in their operation to a particular description or class of persons. So you guys should all read this case because it's a very good one on customary tenure system, right? So under this definition, they're they're telling us that this tenure system is not so dominant. Oh, okay, it's dominant in Uganda, in some parts of Uganda, right? Not the whole of Uganda, but in certain certain regions of Uganda, right? So we are going to look at the characteristics of customary tenure system. We're going to look at some of the characteristics of customary tenure system. One, we've noted that customary tenure system. No, anyways, sorry about that. One of the characteristics is that land was regarded as a common heritage for future generations. So this meant that this land was owned from generation to generation. For example, your father dies. No, your grandfather dies, leaves that land with your father, right? Your father dies, leaves that land to you. You also die, you leave that land to your children, just like that, right? For future generation. Then secondly, rights of land were more defined for groups than individuals. Yes, we've talked about this, that this type of tenure is not held individually, but it's held by a group of persons. Then three, there were traditions and customs followed in customary land tenure. All transactions and use of this land were in adherence to various traditions and customs. Yes, I think this is self-explanatory. This characteristic is under this characteristic, they're telling us that holding of this land was in accordance or in compliance with given traditions and customs. For instance, if you're a Westerner, not Westerner, because this type of tenure system is so common in northern Uganda and some bit of East Uganda. Okay, if you're from East, maybe Basoga, Msoga, yeah, and they have a custom prohibiting you from transferring this land to a person a person who is not a Musoga. So you had to do what? You had to comply with that tradition. Then three, the individual right to possess and use land subject to control by the family and community was recognized, and all this was wired into a framework of multiple rights in land. I think we explained this. Yeah, so dispose of land was strictly in accordance with the customary rules of the area. I talked about this. So you had to follow given rules and traditions in order to have this land disposed of. All members of the community had access to water, grazing, and natural vegetation. I think this is so prominent in those areas. You would have free access to this land so long as you do not you don't sell it off. Then lastly, I know you'll do further reading. Lastly, we note that this kind of land was not registered and it was not titled, right? This land was not registered and not titled. Therefore, individuals who own this type of land used given tools for demarcation. For instance, among the Banyankore, I think they used what they called enkoni. Is it something of the sort, enkoni? Then among the Baganda, I think they have something called Oluwany. Yeah, it's a given it's a given tree, yes, that is used to demarcate boundaries of your land. It's called Oluwani. Okay. Let's look at, having looked at characteristics of customary tenure systems, let's look at how different legislations affected customary land holding in Uganda. So, by so doing, we are going to look at 6 various legislations that affected customary land holding in Uganda. So, we are not going to say much under the pre-colonial stage. By the pre-colonial stage, I mean time before colonization, because under that period, all land was free for use by every person in Uganda, right? So, I think we were colonized in 1888. Was it so? 18? Yes, we were colonized in 1886, I think. I stand to be corrected. So, we are basically going to draw attention to the colonial stage and post-colonial stage, the legislations under the colonial and post-colonial. So let's first of all look at the 1903 Crown Land Ordinance and what does it have to tell us. So under the 1903 Crown Land Ordinance, all customary land was vested into the Queen's government, right? And it was called Crown Land. The land occupied under customary tenure was regarded as Crown Land. I think we've mentioned this. And they're telling us that under Section 33 of the Crown Land Ordinance, the governor had the power to sell the land and lease it to any other person. So let's assess how this affected the natives of those days. Of course, if at all this land was vested in the government, in the Queen's government, then this means that people were deprived of their right of owning land in Uganda. And the fact that Section 36 of the Crown Land Ordinance gave the governor power to sell off this land without even consent of the sitting natives, so it affected them negatively, right? Having looked at that, let's look at the East African Royal Commission of 1955 and look at the recommendations made from this commission. The commission recommended registration and conversion of customary land into freehold, but it remained vested in the state. Which state was that? The government of the Queen of England, right? So it recommended that this land had to be registered, and it provided for conversion of this land into freehold. So I think I think the draftsmen of the 1995 Constitution borrowed an idea of having customary land tenure, of having customary tenure or customary land registered from the 1955 East African Royal Commission, right? So secondly, during the period, those in power were preoccupied with development development of this land, using it as a tool. So this means that those who had power over this land had an obligation of doing what? Of developing this land, right? So, and therefore, the commissioner's recommendation was seen as one of the best ways of boosting investment and development, right? So this meant that in case you had this type of land, right? Maybe we are sitting tenant on customary land, or which was known as the Crown Land, and you did not have money to have it developed, then you would also be deprived of the right to have that land used. It would be given to another person who had the capacity or who had the powers of having it done what? Developed. So how did these recommendations affect the natives? Of course, they affected them negatively and positively. Negatively in the way that if you didn't have money to develop this land, it would be taken away from you and given to another person with the ability to have it developed. But positively, yes, they recommended that this land had to be registered and a provision on conversion of this land into freehold, right? And we shall look at freehold in depth. So let's also look at the Public Lands Act of 1962. The legal status of customary tenure system remained the same even after Uganda gained its independence. Under Article 22 of the Public Lands Act, customary land could still be leased or sold without the consent of occupiers. Tenants were at will with no legal protection from government. Compensation would only be made for improvements, developments, and crops grown on the land, but not land itself. So even that they're telling us that even after independence, because we gained independence in 1962, right? They're telling us that even after independence, the legal status of customary tenure system remained the same, right? This land was vested into the government, right? And under Article 22, this land would be sold or given out to another person without the consent of the occupiers. Tenants were tenants at will. So in case government needed this land, it would come and have it without compensating you if at all you didn't have any developments or crops on that land. So, and compensation would only happen if at all you had improvements or crops on that land. So how did this affect the natives? If we look at compensation, so if I was a poor native who did not have money to develop this land, or I didn't use this land for maybe agriculture, I would be deprived of my right to own this land, right? Then secondly, consent. They did not require my consent to sell off this land or transfer it to another person. So this affected natives negatively even after we gained independence. Let's also look at the Public Land Act of 1962. So, no, of 1969. So we should note that the first act concerning land we had after independence was the Public Land Act of 1962 under King Mutesa I, who at the same time was the first president of Uganda. Then we see another act coming in known as the Public Lands Act of 1969 under, was it Milton Obote? Yes, President Milton Obote, as he then was. So let's look at it in details. It introduced the introduced the request of consent of the customary land occupiers before it was taken over by any other person. This was provided for under Article 24 of, under Section 24. Persons applying for grant of public land had to state whether or not the occupier had freely consented to the taking of this land, right? So the act also gave customary tenancy the right to apply for a lease over that land. We should also note that in the case of Paul Chiseka Saku versus Seventh-day Adventist Supreme Court Civil Appeal number 8 of 1993, it was held that the transfer of a chibanja or customary land without giving notice of the to the prescribed authority was null and void, right? So we see people, we see an advantage, right, or a positive effect under the 1969 Public Lands Act, which introduced the aspect of consent, that every person sitting on customary land had the power to give in their consent in order to have their land taken. And in case these guys did not give consent, that meant that their land would not be taken, right? All right, let's look at the Land Reform Decree of 1975 under Amin. Why is it called a decree? We remember very well that during Amin's time, we did not have a parliament, we did not have the judiciary, we only had the executive. So he was the law and the law was him, right? So he could make laws himself, not parliament, as we know that under Article 79, parliament has powers to make laws. No. And under his regime, he was the lawmaker and the law was him. So they're telling us that under Amini's regime, the Land Reform Decree of 1975 declared all land public land and vested it in the Uganda Land Commission to manage it on behalf of the state. Bibanja holders and customary tenants became tenants at sufferance of the public land. That was under Section 3, subsection 1, and they could be evicted at any time the government so wished. The Uganda Land Commission could lease to another person any land occupied by a customary tenant without his or her consent. They could be evicted by any person who needed this land for development purposes, right? Compensation was not mandatory, but they would only be compensated in case they had developments or crops grown on this land. So the Land Reform Decree of 1975 takes us back to the time of colonization, the period of colonization, because remember, under the the period of colonization and post-colonization, yeah, we remember the Public Land Act of 1962 and the Crown Land Ordinance of 1903, right? So all land again was declared public land and vested into the government of Uganda, right? And the Uganda Land Commission had the mandate to have it managed on behalf of the state, right? So natives of those days became tenants at sufferance. What do they mean that tenants at sufferance? You're there at your own will. In case government needs its land, it cannot even be stopped, and it is not in position of compensating you, right? It could take away this land whenever it wished. So, are we together? They're also telling us that compensation would only be done for developments and crops grown or made on the land, right? So, let's assess, was it, how did the Land Reform Decree of 1975 affect customary land ownership? Of course, it affected it affected it negatively in that with consent was not required, just like the unlike the case in the 1969 Public Lands Act, right? So here the natives' consent was not required, right? Secondly, all land was vested into the government, right? So they were tenants at sufferance, that at the will of government, right? So this land would also be sold to any other person who had the ability to have it developed. So that's how the Land Reform Decree of 1975 affected customary land holding. Then let's also look at the 1995 Constitution and how, in conjunction with the 1998 Land Act, right? And how did these two legislations affect land ownership or customary land ownership? So we should begin with Article 237, which we read. It provides that all land is vested in the citizens of Uganda, right, as opposed to various governments. So this time round, the government gives us a right to own our land in Uganda, unlike previous governments, right? Then secondly, under Article 237, Clause 4, it provides that all citizens owning former public land under customary tenure have a right to acquire a certificate of ownership of their land and to convert the title to a freehold tenure. So they're also giving us a right to do what? To have this land registered. And upon registration of this land, we do not get a certificate of title, but rather we get a certificate of ownership, right? And secondly, we also have a right to convert this land into freehold tenure system. So I would like to ask you, was it to a positive effect or negative? Of course, it was to a positive effect. That unlike previous governments, this time round, all land in Uganda vested to in the citizens of Uganda. So you have a right to own land in Uganda as per Article 237 of the Constitution. Then, Section 27 of the Land Act expressly renders void any customary rule or practice that denies women, children, or disabled persons access to ownership, use, or occupation of customary land tenure system. So this simply tells us that every person in your nature, are you a child, are you a woman, are you a person with disabilities, you have a right to own land. And if there is any custom denying you this right of owning property, of owning this type of land, with reason being you may be disabled or you are a woman, that that tradition becomes contradictory to is it Article 2, Clause 1 and 2 of the Constitution, and therefore it becomes null and void. So this is how we should answer these questions that have that I read to us. I think I should repeat them. One of them's read that assess the impact of written laws on customary land tenure system in Uganda. Then two, written laws did not provide for security of land tenure, to customary landholders. Discuss the foregoing statement in light of the pre-colonial, colonial, and post-colonial era. I told us that if we want to answer this question, we have to rely on 6 legislations, beginning from the 1903 Crown Land Ordinance and how it affected this type of tenure. Then after that, we see the 1955 East African Royal Commission and the 3 recommendations, which recommendations were having this land registered, yes, 1. Then 2, having this land converted from customary to freehold. Then 3, having this land developed, right? Because remember, there was a provision, there was a recommendation that this land ought to be given to people who with capacity to have it developed, right? All right, so thank you very much.